day everyone, my name is Mgbeamu. I'm a 500 level law student at University of Nigeria, Nsukka. I'm currently a virtual intern at HARLEM Solicitors. Within the next few minutes, I'll be discussing on the topic legal rights and remedies of telecommunications consumers or subscribers in Nigeria. Section 157 of the Nigerian Communications Act 2003 defines a consumer as a person who subscribes to or uses telecommunication services. Section 167 of the Federal Competition and Consumer Protection Act 2019 defines a consumer as a person who a. purchases or offers to purchase goods and services otherwise than by resale and does not include any person who purchases goods for manufacturing or production purposes. B. A person to whom services is being rendered. It is important to note that for a person who claims to be a consumer, he must be able to prove the following. A. There must be a sale agreement between the buyer and the seller. B. That the sale was for goods and services. C. That the buying of the goods was for a consideration. D. That the consideration was paid or partly paid, promised or partly promised. E. That the buying of the goods was with the approval of the seller. The International Telecommunication Union (ITU) defines telecommunication services as those services that are offered by telecommunication network or service provider. Section 104, paragraph A of the Nigerian Communications Act 2003 places an obligation on a service provider to a. meet such minimum obligation of quality of service as the Commission may deem fit. B. To reasonably deal with consumers. C. To adequately address consumers' complaints. Also, Section 108 subsection 3 of the same Act, which is the Nigerian Communications Act 2003, provides that all licensees must publish all tariff rates to the consumers and shall not impose tariff charges and costs except to the approval of the Commission. And the Commission here is the Nigerian Communications Commission. Section 2 of the Quality of Service Regulation 2013 provides for the objectives of the regulation, which includes 1. To ensure the protection and promotion of consumers' interests against unfair practices. 2. To improve service quality by identifying service deficiency and effecting adequate changes. 3. To maintain service quality by recognizing environmental operations and standards. 4. To make information available to the consumers in order to help them make informed choices on services and service provider. 5. To improve operation and performance of interconnected networks. Generally, the rights of a consumer include right to quality of service. In this instance, it is expected of the service provider to provide quality services to the consumer. The second right is right to information. The third is right to fair charges and accurate billings. The fourth is right to privacy and protection of private information. The fifth is right to quick redress of consumers' complaints. In the case of UNN and Intern Communication Nigeria Limited, the plaintiff claimed that there was illegal deductions of his airtime and then deductions as regards to caller tune subscription, which he did not subscribe to. The court awarded damages in favor of the plaintiff. Also, in the case of Godfrey Emeye and MTN Communications Nigeria Limited, the plaintiff alleged that the defendant, which in this case is MTN, disclosed his information to a third party, which warranted unsolicited text messages from the latter. The court also awarded damages in favor of the plaintiff. This was similarly held in the case of UNN and Airtel Nigeria Limited. It's also important to note that there is a contract that exists between the service provider and the consumer. However, the contract between these two parties exists at the point where the consumer buys a SIM card and then activates it in line with the directives of the commission, which is the Nigerian Communications Commission. For instance, if Mr. A buys an MTN SIM pack, it is expected that within an access period or within MTN's access period, which is usually 6 months, he is expected to activate that SIM and recharge that SIM. If after the access period he does not recharges his SIM card, that contract ceases to exist and MTN is likely to block his SIM. However, this SIM block is different from the blockage of SIM that is as a result of SIM retrieval. But if Mr. A recharges his SIM and after the access period, the contract continues to exist. Furthermore, amongst all the rights rights of a consumer that I earlier mentioned, the most important of them all is the right of redress, which is the hallmark of every consumer protection system. In order for a consumer to seek redress, there are two principal or basic means for them to seek redress. 1, the Nigerian Communications Commission. 2, the courts. Section 4, paragraph P of the Nigerian Communications Act 2003 empowers the Commission, the Nigerian Communication Commission, to resolve disputes among parties using any dispute resolution mechanisms as the Commission may from time to time determine. Also, another interesting section or provision of this act is Section 74 of the Nigerian Communications Act 2003, which provides that an attempt shall be made by parties to resolve disputes among themselves amicably through negotiation before approaching the Commission. Section 75 also gives the party, Section 75 of the Nigerian Communications Act also gives the party privilege to approach the Commission in order for their dispute to be resolved. It is a trades law that where a statute stipulates internal mechanisms for dispute resolution, such mechanisms must be adhered to first before approaching the courts. This has been held in several cases like Abubakar and Nasamu. Section 138 of the Nigerian Communications Act 2003 provides that the Federal High Court has exclusive jurisdiction to determine matters as it relates to the enforcement of obligation of service providers. However, Section 172 of the 1999 Constitution gives the State High Court jurisdiction to determine matters as it relates to breach of contract and not enforcement of obligation of a service provider. In the case of Nsukka and MTN Communication Nigeria Limited, the plaintiff bought a SIM pack, activated it, he recharged it, but he was unable to fully enjoy the services which he actually paid for. And he claimed, we approached the court, the FCT High Court, claiming damages for loss and inconvenience which he has actually suffered. This FCT High Court, which is a state high court, dismissed the suit, holding that the court does not have jurisdiction to determine such matters. He went on appeal, and the Court of Appeal held that the state high court has jurisdiction to determine matters that relates to breach of contract between the service provider and a consumer. Thank you for listening, and I hope you enjoyed this video lecture. For more clarifications and questions on telecommunications law, you can visit our website at www.harlemsolicitors.com, or you can follow us on our social media pages by searching for HARLEM Solicitors. Thank you once again.